Welcome back to my YouTube channel VaJee Law, a center for legal excellence. In the series of IBC Amendment Act 2026, again we are back with what are the amendment introduced in Section 35. 35 represent a significant move towards eliminating administrative friction by streamlining how the claims are handled. The law ensures that the CIRP and liquidation phase are no longer treated as two distinct processes, perhaps a one continuous process. Let's go through it into detail. First is mandate for an updated claim under Section 35, subsection A, subsection 1, clause A. And in the original code, the liquidator was tasked with independent duty to verify claim of all creditors. This often led to redundant repetition of work already performed by RP during CIRP. The substituted clause A now requires a liquidator to maintain an updated list of claim of creditor in such a manner as may be specified. This change implies that the list of claim is a living document carried forward from insolvency phase. The liquidator role shift from an investigator of claim to a custodian and updater of existing verified list. In my opinion, there should be a technological integration to effectively carry out this change, like in a integrated platform for insolvency ecosystem, a national registry intended to ensure a single source of truth across the various processes. Like an information utility, we have to record a default. Every financial creditor has to record a default with information utility, and whenever they are filing a petition under section 7, they need to produce an NESL report. Here we can also do the same with other financial creditors, other creditors during the CIRP. And this is completely my opinion. Let me know what are your opinions in the comment box. And second is eliminating the investigation invitation stage. 35 subsection 1 J provides omits the word invite, and under the previous amendment, under the previous framework, the liquidator was required to make a fresh public announcement to invite a claim from creditors within 30 days of the liquidation commencement date. By removing the requirement to invite claim, the law recognized that the creditor have already submitted and proved their debt during the CIRP. The liquidator now moves directly to the settlements of claim and the distribution of proceeds. This prevents the wait and see period and previously delayed the start of actual winding up of the estate. Now, from this effect, because of this is a procedural amendment as well. Omission to section 38 to 42. The most drastic procedural change in the total omission of section 38 to 42 of Principal Act IBC 2016. This section formally provided for like consolidation of claim. 38 provide for consolidation of claim. 39 provide for verification of claim. 40 provide for admission or rejection of claim. 41 provide for valuation of claim, and 42 provide appeal against the liquidator decision. By omitting these, the 2026 Amendment Act removed the major source of litigation and delay. Under the new model, the adjudication of claim performed during CIRP is final and carries through into a liquidation unless there is a specific update required. Okay, and next is the carry forward mechanism. The streamlining of claim is made possible by the newly substituted section 34 subsection 5, which establish a mandatory link between RP and the liquidator. The resolution professional is now legally required to forward to the liquidator all the records relating to conduct of the corporate insolvency resolution process. The liquidator relies on the verified data established under section 18, where the IRP originally received and collated all the claims submitted by the creditors. And similarly, if the valuation was already conducted during the CIRP, the liquidator is generally expected to consider those values for liquidation state, avoiding the cost and time to fresh valuation unless absolutely necessary. Okay, next is the picture, accelerating the transition. The cumulative effect of these changes is to signify the reduce the transition time from the resolution phase to a liquidation phase. Previously, what happened now? The claim process is the claim process in liquidation could take months of administrative work. Now, because of the data is on the self and verified, the liquidator can begin managing the selling of begin managing and selling of asset almost immediately upon appointment by eliminating redundant public announcement, fresh claim filing, and duplicative verification exercise. The liquidation costs are lowered, which ultimately increases the amount available for distribution to creditor under Section 53 waterfall. By relying on the clean slate established during the CIRP, the process avoids the re-agitation of undecided or the legacy claims, providing more certainty to potential buyer of the corporate debtor's asset. Okay, now in a nutshell, we can see that it's a continuous journey. Like Section 8, claim verified by IRP, verification and adjudication by IRP, and the committee approves those claims under Section 21, verify claim list on a single source of truth if we create, otherwise to RP himself need to maintain this record and in a specified manner as IBBI will specify, and this all the brain is storming and all the time and effort save in the process of liquidation. And these all the record are seamlessly handed over to the liquidator. RP forwarded all those record to liquidator under section 34 subsection 5, and liquidator maintain updated list of claim. He is not inviting, he is only maintaining updated list of claims and no fresh invitation. He is directly proceeding towards the settlement and distribution to the creditors under Section 53 waterfall mechanism. Now, this is the seamless process. Okay, what are the impact of this? Impact is very clear that it's time saving, which is very clear. I already explained you that say suppose a financial institution and there is a very long process that you need to file a claim with RP and RP verify from the books of accounts of a corporate debtor, and if no record is available, that from your he asked for you to prove your claim, and there is a quite time taking process. All this is now reduced in the phase of liquidation. Cost reduction, no fresh announcement, paper publication में भी पैसे लगते हैं यार that is saved now. And sometimes liquidators some or more major time liquidator has to spend these initial expenses from his own pocket, and then after it get approval from liquidation cost in when a stakeholder committee constituted earlier. But now this cost is safe. No duplication, verification, lower administration, and lower litigation cost as well. If say suppose you reject someone claiming, it goes to adjudicating authority. Now, Section 42 appeal provision is there. Now that is also reduced. You say कि मैं कुछ नहीं कर रहा हूँ. Whatever is done by RP, I'm just only carry forwarding it. And legal certainty, adjudicating authority in CIRP stands unless specific update are needed, fewer dispute and more certainty. There is legal certainty as well. Now, creditor values quicker realization and efficient process lead to the higher distribution under Section 53. Investors' confidence and efficient process enhance trust in the insolvency ecosystem because everything is now transparent. Okay, next go through it. Next, we are proceeding. What are the amendment introduced in Section 35(1), clause L, and substituting Section 26? The law established these proceedings have a life independent of the corporate debtor existence. Means here the framework ensures that the legal action against the former management for the asset diversion and misconduct are not abandoned. By amending Section 35, subsection 1, subclause L, and substituting Section 26, the law established that these proceedings have a life independent of corporate debtor existence. Let's go through it in detail. First is expanded statutory mandate for liquidators. The amendment replaced the liquidator early duty to investigate with the proactive legal mandate to continue or institute a legal proceeding in respect of the avoidance transaction or fraudulent or wrongful trading. Here is the word use continue. The liquidator is now legally required to take over and pursue any application already filed by RP during CIRP. And next word is institute. Means the liquidator has the authority to initiate new legal action if they are discovered suspect transactions during the liquidation phase that were not previously identified. The This mandate covers the avoidance transaction. Avoidance transaction has a consolidated definition under Section 5, which includes preferential, undervalued, extortionate creditors, transaction defrauding creditors, and fraudulent and wrongful trading as defined in Section 43, 45, 49, 50, and 66 respectively. Okay, next is alignment with process independence. The substitution of Section 26 ensures that the pursuit of misconduct does not stall the timeline of insolvency or liquidation process. The filing of application for avoidance transaction or fraudulent trading shall not affect the proceeding of CIRP or liquidation process. This allows the liquidator to sell the asset and distribute proceeds while simultaneously litigating against former management. A new explanation to Section 26 explicitly declares that the completion of CIRP or liquidation process shall not affect the continuation of proceeding. This prevents the former management from escaping liability simple because the company has finished its winding up process. Okay. Next is sur survival post dissolutions. The most significant detail of this amendment is that the misconduct proceedings, like preferential avoidance, what are the proof transaction, whatever the proof transaction are there, survives the legal debt of the corporate debtor. Under a new section 54, subsection 2b, the passing of a dissolution order by adjudicating authority which formally ends the company existence shall not affect the continuity of the proceeding initiated for avoidance transaction and fraudulent trading. If such proceedings are pending when the liquidator applies for a dissolution, the committee of creditors is empowered to determine the manner of pursuing these cases and how any future proceed realized from them will be distributed. The COC also make an appropriate arrangement for the distribution of the proceed and arising out of such proceedings, ensuring that creditors can still benefit from claw back and even after the company is dissolved. Next is direct creditor action under Section 47. To further ensure accountability, the law provides a fallback mechanism. If the liquidator RP fails to report or pursue any avoidance transaction or fraudulent trading despite having a sufficient information, a creditor, member, or a partner of the corporate debtor may apply directly to the adjudicating authority for relief. If the adjudicating authority finds that liquidator was negligent in this duty, it can order the IBBI to initiate a disciplinary proceeding against them. Okay, next, go through it. Reforms introduced in section 35 subclause 2 represents a fundamental shift from a liquidator led process to a creditors driven model for a liquidation. First is from non-binding consultation to active supervision. The most significant changes lies in the legal weight of the creditor rule. Under the old section 35 subsection 2, the liquidator had the power to consult stakeholders, but the law explicitly state that such consultation was not binding on the liquidator. The primary advisory body was the stakeholder consultation committee, which provided advice that liquidator could choose to override by recording reasons. The substituted section 35 section 2 now declares that the committee of creditors shall supervise the conduct of liquidation process by the liquidator. This removes the non-binding qualifier and establish a formal hierarchy where the liquidator operates under the direct oversight of the COC. Okay, continuity of the COC. Continuity of the COC. Under the original code, the COC formal existence generally ends once the liquidation order was passed, giving a way to SSC, Stakeholder Committee. The 2026 amendment ensures that the COC constituted during the CIRP constituted into liquidation. Section 21 subsection 11 specifies that COC will continue to supervise the liquidation supervise the liquidation, ensuring that institutional knowledge and commercial strategies developed during the resolution phase are carried forward. The COC retains its voting structure based on the financial debt, allowing the major creditors to exercise the better commercial oversight over asset sale and estate management. Next is better commercial oversight. What is the better commercial oversight? Protect, protect and preserve asset. Number one is protect and preserve asset. Oversee step taken by the liquidator to protect, preserve, and manage the asset of the corporate debtor. Number two, as a going concern management, monitors the decision of running the business as a going concern where viable to the maximizing value. See, suppose there is a hotel business, and you know that whenever there is a Shubh Muhurat of marriage, it's run very smoothly. So then COC may take a decision, okay, hold your bidding for some time and just fetch more business, and then after go for a sale. So they can take these kind of decision during COC so that the value of asset can be maximized to its best extent. And third is evaluation and realization. Review the asset valuation, manner of sale and marketing strategies and other commercial decisions, because COC is fully functional as it's a function under the CIRP. Review of conduct. Creditor can regularly monitor the liquidator activity and seek rationale for key decision. They have a right to ask by what authority you are doing these things. And next, uh, instruction on the manner of sale. COC has a greater say in the manner, timing, and mode of sale to ensure the best interest of the creditors. I already explained this. Okay, uh, next is the power to replace. Section 34A, capital A. The 2026 amendment provides the COC with a powerful mechanism to enforce its supervisory role. सीधा सा हिसाब, हमारे हिसाब से काम नहीं करोगे हम हटा देंगे, सिंपल. If you want to work, you have to work according to the best interest of creditors, not according to your interest. Section 34A. If the COC of this opinion that liquidator is required to be replaced, it may resolve to do so at any time by the vote of not less than 66% of voting share. Unlike the previous provision, the requirement proven there is that required proven misconduct for the removal. Section 34A allows the replacement based on the COC commercial judgment, ensuring a liquidator remain accountable on the body supervising them. Okay, next is hmm, next is provide clear this there is a balanced transition. This provide a clear roadmap for how these changes apply to a current and future cases. The Act uses a bifurcated approach to applicability, keeping the old claim process for existing liquidation to avoid the disrupting legal finality, and while immediately empowering the creditor with the supervisory role to improve commercial outcomes. First is First is prospective application for claims. The Act inserted a specific explanation to Section 35, subsection 1 to prevent the retroactive disruption of the claim process. The new mandate to maintain an updated list of claim and under Clause A, 35(1) Clause A, and the removal of a requirement to invite claim under clause J do not apply to the liquidation process initiated on or before the date of the 2026 amendment commencement. Whenever it commences, that does not affect previously instituted case. Similarly, the omission of section 38 to 42 does not affect the existing case. And what rationally behind it this that for companies already halfway through their liquidation, switching the claim model would create a massive legal confusion and potential restart the clock on already verified debts. By keeping these rules prospective, the law ensures procedural certainty for those already in the old pipeline. Now, whereas in contrast to the claim rules, the new supervisory power of creditor applies immediately, even to the most ongoing cases. This is governed by the explanation to new section 21 subsection 11. What it says that the provision required a COC to supervise the liquidation under section 35 subsection 2 and the power to replace the liquidator by 66% of voting. Section 34A apply to liquidation process initiated after the 2026 Act, ongoing liquidation process where the liquidator has yet to make an application for dissolution under section 54. There is what is the practical impact of this? Say suppose if a company is in liquidation but hasn't yet finished the process, the old COC is revived and must continue for the remainder of liquidation to provide oversight. This reflects the legislature intention to instill commercial accountability into the process as quickly as possible. Okay, now I just provided a summary for your convenience. What is the position after, before the amendment and after the amendment? Let's go through it one by one. For a quick revision, number 1 point is claim handling. Liquidator has required to issue a fresh invitation and verify claim earlier, but now position is changed. Liquidator need to maintain only updated list in a specified manner, relying on the data verified during the CIRP to eliminate duplication of claim and other administrative tasks. Next is claim handling. uh, earlier uh, Next is earlier COC rule. The COC rule generally ended at the start of liquidation. Liquidation phase constitute a committee, stakeholder committee, and the stakeholder committee is advises only directory, not mandatory in nature. But now COC officially supervise the conduct of the liquidation. Its oversight is mandatory and formal, as in CIRP. Next is replacement of IP. Replacing a liquidator was difficult and generally required proving misconduct or failure to perform a duty. Now the COC can resolve to replace a liquidator at any time by the vote of not less than 66% of voting share. Earlier, liquidator had a general power to investigate the financial affairs to determine the suspect transaction. Now, the liquidator has a explicit mandate to continue or institute a legal proceeding for avoidance transaction or fraudulent trading. Earlier, misconduct suits were often viewed as tied up to the life of the corporate debtor, potentially stalling the dissolution. Now the process independence. The dissolution of company does not affect the continuation of misconduct proceedings, say a PUFE or avoidance transaction proceedings, which can survive the company legal death. Survive, which can, if a company is dissolved, doesn't mean that avoidance transaction or fraudulent transaction trading also come to end. They can survive even after that dissolution as well. And earlier, highly prone to the procedural bottleneck and delays due to re-verification of claims and litigation and administrative rejection. Now, target is 180-day window for completion, focusing on the asset sale and distribution rather than an administrative rework, which is already done in CIRP. Hope I explained this amendment to up to your expectation. If anything needed to be added, just let me know in the comments. Thank you.